أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم أستغفر الله ربي وأتوب إليه الحمد لله رب العالمين والصلاة والسلام على خير خلقه وخاتم الأنبياء والمرسلين سيد الأولين والآخرين شفيع المذنبين رحمة للعالمين محمد وآله الطيبين الطاهرين المعصومين اللهم صل على ربنا لا تزغ قلوبنا بعد إذ هديتنا وهب لنا من لدنك رحمة إنك أنت الوهاب. Assalamu alaikum, my dear brothers and sisters. Jazakallah for the humble invitation. It's always nice to be back. See the usual Friday crowd. That means like the rest of the center unfortunately is not filled. But inshallah, whatever small knowledge I have to offer, inshallah we will all benefit from each other. When I was invited, I did tell Miqdad, is it a wiladat or a wafat? So unfortunately, it's going to be a kind of academic lecture, which means I know factually that 33% of the audience will go to sleep. The other 33%, I'm not sure, 50-50, and the other 33% will be, inshallah, interested. So apologies, but we don't always get the opportunity, so that's the aim, okay? Sorry. As was advertised, the title is Systems of Conflict or Collaboration, the Relationship between Fiqh and International Law. Now, why have I chosen this topic and what's the nature of it? I chose it basically, one, as a matter of sharing research, and second is because in our globalized world, I think what is happening is there is a fundamental question being posed. Two questions being posed. I only want to deal with one. One is the theory of fiqh, which is usul al-fiqh, which I'm not going to go into. The other question is related to fiqh as a system, as a body of law which requires implementation by the average believer or implementation by the ummah. So whether it comes to khums or zakat, whether it comes to wars if you're a Muslim state, whether it comes to a constitution. How is fiqh relevant or working as a system or a body of law that guides religious believers in whichever country they are, or when there are conflicting jurisdictions or systems of law, perhaps. So we live in this country, and there are certain legislation which applies to us, perhaps the Human Rights Act, perhaps a court structure, which may conflict with certain rights and systems within fiqh. What I want to focus on is how are we applying fiqhi or jurisprudential laws in an extremely globalized world, one. Number two, in a globalized world that whether we like it or not, is governed by international law, which I will define. Whether we like it or not, whichever country we go in, we have to respect norms like freedom of expression and right of privacy and right of life, right to a fair trial. We may disagree to the extent of some of these rights, but we are governed by them. Why? Because international law does not deal with citizens of countries. It deals with human beings as human beings, regardless of whatever citizenship they have, religion, race, or gender, or culture, or anything else. So this is now something which fiqh as a system has to consider as it operates throughout the world. And the third thing which is linked to this is what similarities and differences are there between the two systems. And the reason that I'm posing this question, again, this is the premise which I'm operating on, is that fiqh has become a kind of Muslim international law for religious believers. That's what it has become. Why? Because when we simply ask the question, if we go to Australia or Pakistan or Africa, wherever we go, if we ask the question, does my fiqhi law apply in this country? Is what my jurist is telling me applicable in this country? By us asking this question, which we always do, we are presuming that fiqh is applicable internationally or universally, which is a huge presumption that we are making. we are assuming that the jurist's laws carries across all continents. And we are also assuming that whatever evidence that we have, whatever knowledge of law that we have, whether we are scholars or not, we are assuming that that knowledge gives us enough confidence as a religious believer to make a decision about an action, and we can do so very confidently, despite the fact that we are in a different country, a different system of law, with different kinds of rights. So the premise which I'm operating on is, I humbly believe that fiqh has become an international law, but I do not believe it is recognized as such by the vast majority of scholars. And the purpose of this lecture is not to criticize either system, in fact, is to analyze both systems. And the reason why it has become this kind of international law is simply put because of globalization. That's the fundamental reason. We can migrate easily wherever we want. We can travel. In fact, we can access each other through the internet. So what's happening is that we are asking the usual questions. Can I do this or can I do that? As the world changes. And here comes an important paradigm shift, which we cannot blame our respected scholars before for not fathoming. It's difficult. When you read histories of fiqh, the traditional paradigm by which the system of fiqh evolved, which is, I think, virtually accepted by all, at least Shi'i scholars, and again, I think this lecture applies to all Muslims, but I'll make reference to Shi'i fiqh. The paradigm was that our dear 12th Imam, may Allah hasten his reappearance, is now in Ghaibatul Kubra, is now in the major occultation. So the paradigm was that we are distant in time from him. As we often say, the legislative era for Shi'i Muslims has ended by the Jazakallah. In Muharram, I got bigger glasses. Just a joke. Don't worry, anything will do, alhamdulillah. The paradigm was that as the 12th Imam has gone into the major occultation, how do we access the Imam? There's no active guidance from the Imam anymore. So the paradigm was distance in time, okay? Distance in time. So now we have to fend for ourselves. And therefore the respected efforts of Sheikh Mufid, of Sharif al-Murtada, of Sheikh Tusi and several others even beyond that, have been to pioneer jurisprudence, have been to pioneer a way in which we can somehow find out the will of the Imam, and thereby the will of the Prophet, and inshallah the will of Allah subhanahu wa ta'ala. So the paradigm was distance in time. Now there's a new kind of paradigm, which is distance between us, really. That's the key paradigm at the moment. It's not just about the 12th Imam. It's about how proximate we are to each other, how accessible we are to each other, how we make decisions as individuals. Kostas Douzinas has said something very interesting, and he's a professor at Birkbeck University. And the reason I'm going to quote him is because he's one of the people that analyzes modernity, how our globalized world is evolving. And he says there is one unique thing about our civilization today, which he and many other scholars like Charles Taylor have said, which has not been present before, and this is because of technology and migration. He says, modernity, or the modern civilization, does not just enthrone the individual. It is the epoch of the free reign of will and its darker companion, desire. He's saying what characterizes our civilization today is, one, the individual is at the center of everything, and he can control everything. And we have various ahadith, again, I haven't looked at the veracity, but I'm just recalling this, related to the 12th Imam or the end of times, where a person goes out of his house and becomes a kafir and then comes back into his house. Leaves his house, seemingly going with piety, but then coming back in with a kind of disbelief. Why? We all know what is there on the internet. We all know how people can manipulate the internet. We all know what things happen over Facebook. We know how networks and systems can be set up by criminals, or mobile phone, I don't know what they're called, networks or whatever you want to say, where they can commit crimes without them being acknowledged by the police radar. I mean, I can mention many examples. Whatever age we are in, we somehow are surrounded by so much opportunity, but also so much chance for destruction. That's why I said individuals are characterized by this desire. They can let out their desire because nobody's monitoring them. Nobody is policing them. Now this gives a very unique paradigm to fiqh. So now the paradigm for fiqh is, one, the distance between us. And second is the distance really in myself, me as an individual being able to exercise my desire. Salawat. So inshallah I've given you the context. How now is fiqh and international relevant? Firstly, whether it is fiqh or not, doesn't matter. Whether it is international or not, doesn't matter. Any system of law is concerned with one thing only, and that is social order. Social order. It's there to command things to people. Stop at a red light. If you don't pay your taxes, you'll be punished. Do not steal. Do not enter into somebody else's garden. It's there to give commands and also recommendations and guidelines. So at our workplaces, we have guidelines of how to treat employees. Guidelines, not necessarily rules as such, but guidelines. So law as a system, it doesn't matter whether it's a religious system or not, it's the same thing. There's nothing special about fiqh and there's nothing special about international law here. Order, that's what we want. Order for religious believers. However, where there may be a difference is the structures which develop, the kind of court systems which develop, maybe the kind of notions of justice we have, the kind of parliament or system of government that we develop. And we see that throughout the world. And here we come to arguably a crucial difference. Fiqh simply is the procedure by which the derivation of Shari rulings takes place. The derivation of Shari rulings, these are the key words. We are concerned about a system of law which derives rules in order to equate or reflect the will of Allah subhanahu wa ta'ala, a way or path to God. Our system is concerned with rules which we hope would please Allah or lead us back to the Prophet. That's what we are concerned about. And that's a very noble aim of, I think, a religious legal system. And I don't think there's any source of conflict about that, despite what is printed in the news about Sharia, etc. How we define Sharia is another matter totally. But that aim of wanting something more than oneself is a noble aim. So what is international law? International law is concerned simply about how states regulate their relationship with each other. Can I invade this country? These are my resources, you can't have them. We have signed this pact of peace. We have signed this pact of where this train can go and where this transport route can be laid. It's a relationship between states. But what has also happened, especially after World War II, international law regulates the affairs of human beings, regardless of which state they're affiliated or which state they are from. So now, therefore, if somebody comes into this country and is known as a foreigner, as we say, if he commits a crime or she commits a crime, what jurisdiction or what court system governs that crime or that action of that individual? Is it Spain, where he or she was from? So does the Spanish government then enter into this British jurisdiction? That is one aspect of international law. The other aspect is what happens when I am not satisfied with my own government, when I'm not satisfied with the actions of my government going to invade another country. What rights do I have? What happens if, like in Bahrain, as we discussed in Muharram, what happens if my freedom of speech is not there anymore? Where do I go? Surely, as a human being, I have rights which transcend the state. Surely, I, as a human being, I'm a rational person. I have a dignity. Why is my dignity being harmed? I don't want my tax money. Well, I don't want my money to go and fund the army. So there, international law says, wait, you can go to the ECHR, the European Court of Human Rights. There is jurisdiction there. You can carry your claim to a greater court than the one that your state is providing. So now look at what's happened. Look at how much power the individual has. Now, of course, it's a different question as to really how much power do we have. But theoretically, we have a lot of power. So international law is not concerned with Allah subhanahu wa ta'ala, as you have obviously understood. It's not concerned with God. It's concerned with satisfying the human being's dignity, the human being's rights, and the human being's claims. Whereas our fiqh system is concerned with a fundamental question, which Imam Zainul Abidin says in Risalat al-Hukuk. At the start of Risalat al-Hukuk, the greatest of Allah subhanahu wa ta'ala's rights that He has against us is His own right, simply because He has created us. In fact, that's a wonderful starting point of law. So here, the two systems automatically differ into who they are pleasing. Salawat. Now, when looking at this relationship, we're already seeing some similarities and differences. The first similarity, as I have posed, is we do ask the question, does my faqih's decision, if you like, or does this law which he has derived, does it apply in any context? But the difference is that, well, there's a different vision of fiqh and a different vision of international law. But there's another thing, which is a rather interesting thing that we do. We believe that the risala that we have, the risala of a jurist, is a universal piece of legislation. That's how we treat it. We carry the book wherever we go, or now internet, and we will look up what our jurist says, whichever country we are from. To us, that is a universal piece of legislation. In the same way, international law has universal piece of legislation. Human Rights Act 1998, Universal Declaration of Human Rights. This is universal piece of legislation, applies wherever we are. So we treat the Risala as a universal piece of legislation. And my question is it universal? Does all the laws, or do all the laws apply in every context? In the same way that whilst the international legislation will say that we have the right of privacy, but it's up to us to define it the way we want to as well. This is another thing. What I do in my own home is not of concern to you. So there's a universal right, but then I define it. Then we come to a second aspect of these two systems, which are the sources. In international law, Article 38 of the Statute of the International Court of Justice 1945 states that there are 4 sources of international law. International conventions known as treaties or pacts, that Britain signs a pact with America or Britain signs a pact with Africa. Okay? And this has to be signed, and this is binding upon the states. They can't escape these treaties very easily. Then you have international custom, which is basically the custom of the international community. So again, I'm giving the example of Bahrain because I've done some research on it. It has been the custom of the international community to ignore Bahrain. So therefore, the law pertaining to Bahrain is to allow the Bahraini government to treat its citizens in accordance with its own processes. However, if the international legal community decided to act, then it would interfere into even the constitutional processes of Bahrain. So custom can be abused, or custom can be a good source of power. Okay? A third one, the general principles of law recognized by civilized nations, which you may say is rather insulting to third world countries. Okay? What is civilized? Who are civilized? Is British society civilized? Are the young people of Britain civilized? It's questionable. Is Africa civilized? Yes, you could say. Maybe it's not civilized in terms of the economy and the processes that it has developed. So this is a very Euro-American kind of process. However, what it basically means is, if I'm being objective, is you can't put anybody into slavery. That is a principle of a civilized nation. You can't be barbaric. Okay? So a principle of a civilized nation is not to do anything which harms the dignity of human beings. And the fourth source of law, judicial decisions and teachings of highly qualified publicists. And still today, international scholars don't know what that means. It can mean judges' decisions. It can mean scholars. It can mean NGOs. It can mean bodies which protest, all sorts of people. Okay, and even they can be abused as well. So here, judge decisions actually have some leeway. Now these are the four sources of law. This is how international law operates. What about fiqh? Again, there is a similarity. And again, I say this because I do not believe that in the structure of the Quran, Sunnah, Ijma and Aql, there is anything special. This is all Aqli derived. Quran equates with international conventions. Why? Because you need a foundational source of law that is not dependent upon human whim. You need some constitution. You need something written down. You need a Charter of Medina. You need the 10 Commandments. You need something which people can go back to and say, this is the source of our civilization. This is the source of our religion. Thus, theoretically, there is no difference between international conventions and the Quran. In terms of content, yes, of course there's a difference. You're talking about something man-made, treatise, and you're talking about the Quran, which we believe is divinely revealed and accurate. Contents differ. But theoretically, there's no difference in identifying a foundation of law. Then you can guess what I'm going to say. Custom, which equates with sunnah, which is the habits and the practice and the deeds, the tacit approval, the sayings of the Prophet and, in terms of Shia fiqh, the dear Imams. So custom, I mean, how did people behave? How are people behaving now? Are they reflecting the will of the Prophet and the Imams? But more importantly, we want to see how holy people acted. So for the international community, the holy people would be states. Because in accordance with their eyes, states are, if a state is formed, that is a sign of some kind of civilized entity. And you'll find, for example, with Turkey, the ongoing kind of debate, whether it is part of the European Union, should it be part, to what extent are its relations with the European Union. It's about recognizing whether it's a legitimate, civilized kind of country. Same sort of thing. So here, we point to the Sunnah of the Prophet and the Imams. General principle law recognized by civilized nations, ijma, is consensus. It's the kind of things which our ulama consider to be acceptable over time and which should last us. That's ijma. And it's the same thing with the international community. What is civilized? What can last the world? What can last the international community? Slavery, yes, it should be abolished because that's something for the prosperity of the international community. And the same thing that we may identify with ijma. And then, of course, judicial decisions of specific people, which is basically our use of aql. This is very individualistic. A judge's opinion may conflict with another opinion. And in the same thing, our use of aql, or what one jurist may say, may conflict with another jurist. Therefore, can we immediately see that there are some similarities with international law and fiqh, and of course, immediate differences. Salawat. Then we come to another aspect of this relationship, which is accountability. As a religious believer, I am accountable foremost to Allah subhanahu wa ta'ala. I may be obedient to the Prophet, I may want to follow the Prophet, but I'm accountable to Allah subhanahu wa ta'ala. In international law, as a human being, although I'm given these rights, I'm accountable to the structures in my country, to the court systems and to the police. Now, in a Muslim state, yes, these same structures would apply. However, this British system of law, or as we are talking international legal system, does not tell us to ask the question, look inside your conscience. It doesn't tell us to do this. Fiqh does actually tell us to do this. It tells us, would your God be pleased? And again, this is a very noble thing about a religious system and especially about a fiqh system. Now, who we are accountable to, there's a huge difference. But in a Muslim state, there is little difference. There's another interesting thing with fiqh. We are expected to do the right thing. How do I put this? if I don't pay my khums, is anybody going to say anything? If I say that, let's say I'm negligent, I don't care for 1 year, let's say, I don't want to pay my khums, I just forget about it. Or maybe I don't find a trustworthy person to give it to, or I feel that my money is not going in the right place. For example, these are legitimate concerns which people raise. If I do not pay my khums, who enforces my action? Who monitors my action? One. Now, I'm posing this question because in my humble research, I don't believe we have considered the question of enforcement in fiqh, whether we are residing in a Muslim state or not. Tax is one thing. Khums, zakat, other public duties, even amr bil ma'ruf, nahy anil munkar. Who enforces these things? The reason that I say this is because khums concerns the public good. After all, people need that sustenance. People are poor, or we need to build hospitals and schools and whatever. So if I don't pay, I'm causing a problem to my ummah. So has fiqh, as a practical system, as a procedural system, regardless of whether we are in a Muslim state or not, does not matter. Has it concerned the issue of enforceability? After all, who's going to monitor me? What I'm saying is it too much to say to a person or too much to put in the system? Well, this person has iman. It's okay. He's answerable to Allah subhanahu wa ta'ala. It's not a problem. This is a big presumption in a globalized world where, as I said, the individual is free with his actions. So, as a practical system, is fiqh effective in an increasingly globalized world in enforcing, if you like, furu'id din? Is it really effective in its enforcement? International law has, by the way, the same problem. It is extremely poor in its enforcement. Why? Because states can manipulate international law, and the Iraq war of 2003, or rather the Iraq invasion of 2003, is the best example, where many people protested in this country, exercising their right as citizens and as human beings, but this was ignored. And as we know, there were no weapons of mass destruction. So now, who is going to put Tony Blair and George Bush under trial? And if you read the book, The New Rulers of the World by John Pilger, he's very scathing to Western governments and Western presidents, saying who holds them accountable. They may put Saddam Hussein on the list of dictators, but it is possible to put, for example, presidents of some Western countries on that list as well. So therefore, who holds these people accountable again? There is again a similarity, and I don't think it's a very positive similarity, which is international law suffers from a lack of enforcement. And to some degree, fiqh also suffers from a lack of enforcement. So this is about procedure here. I was going to mention some terms, but mu'adhiriya and munajjiziyya. Mu'adhiriya, I am excused if I don't know the law, or if I'm disobedient to the law and I don't have knowledge of it. I've acted maybe even with my certainty, but really I have no knowledge of what I'm doing. And there I'm excused in front of Allah subhanahu wa ta'ala. But if I do know that yes, I'm not meant to drink this glass of wine, for example, and I do drink it, then Allah can hold me accountable. Now these principles which are there in ilm al-fiqh are not, I don't know how to put this, but are not considered currently within how they are applied or implemented within the action of a religious believer. Theoretically they may be fine and very wonderful, and it's very noble, but to be fair, who checks our actions, especially when the rest of the ummah depend on my action? Then you have another issue, which is private and public law, which some of you may be familiar with. Again, I'm trying to be as clear as possible. In fiqh, you have usul al-amaliyah, which are practical principles, which simply put, if I don't know about the law, I'm exempt, bara'ah. Or if I know something exists, or there are two glasses here, one's Ribena, one is wine, I don't know which, the color is the same, I should do ihtiyat and not drink either one of them. Okay? Now, this is very wonderful because when the Quran and the Sunnah do not stipulate a law, or we don't have any guidance for extracting a law, then we have a private space of how to act. Okay? We have a private space. We are exempt, or we do ihtiyat, etc. However, fiqh looks at the human being, the religious believer, as somebody that is incapable of making a proactive private decision. Usul al-Amaliya are restrictive. It's a defensive principle, a defense mechanism. I'm exempt. Oh, there's two things, okay, ihtiyat. With international law, when, for example, the Human Rights Act says, you have a right to your privacy, it does not define the privacy. It doesn't tell you, how you should behave in your home, how you should behave with other people. It doesn't tell you that. You have a right to freedom of speech. So I want to draw cartoons. I want to write a novel. I want to produce a film. Fine, no problem, do it. Provided it's within the bounds of the law of a state, there's no problem. Okay? Now, I'm not saying anything positive or negative. I'm trying to describe the two systems. Fiqh is more restrictive in terms of private situations. So there isn't an element of proactive choice. How I behave in another person, or how I behave in a restaurant, is even legislated by a fiqh system. So with the example of in a workplace where specific laws exist, whether it's shaking hands, whether it's how to behave with the employees. So my question is, should fiqh go to that degree? Should it allow a level of freedom in the implementation of law for its religious believers? And I'm not saying international law is perfect either, because as we know, then especially as Muslims, if something like homosexuality develops, that would be a great source of conflict for us. And so you always have to have a degree or a kind of limit there, where the right of privacy is fine, but then if that goes into society, and especially as Muslims who believe, no, this is something which is a corruption or something which is sinful, then how do you legislate that action when it seeps into the public domain? So again, I'm just posing the question. I don't have the conclusion, but I'm posing the question, especially in this globalized world, to what extent should fiqh allow a level of choice in the implementation of law? Salawat, please. I think a final area. Sorry, I have to think a bit. International law is driven by values, which is very obvious. It's driven by human rights. As I said, whether it promotes them in a just way is highly questionable. Whatever we say, human rights is, international law is founded basically upon human rights. You don't enslave anybody. You don't be barbaric to anybody. You respect the dignity of people. It's founded, in fact, upon human dignity, because people didn't want World War II to be repeated again. So international law is a values-driven order, and it's very purposeful. My question is fiqh a value-driven order? So take Eid as an example, which you always have a conflict at the end of Ramadan. It is based on personal certitude. If I identify the moon, or if they're reliable witnesses, etc., etc., this is Eid for me. I don't have to follow the community. It's fine, no problem. Okay? If one community does it, and another community doesn't, or does it on a different day, then fine, it's no problem. But again, in a globalized world, should fiqh first of all legislate a principle of unity and then pull the laws to that? So one example is unity. And therefore, all other interpretations are now pulled to that principle. International is value driven. But the problem, as you know, is now, if I go and travel in a different country, or I'm doing my Eid in this community, there's a source of conflict for me, because my family at home is doing Eid at a different day. And that makes me sad. No, I mean, sad not because I'm sad I'm sad genuinely, like emotional. Because I can't do Eid with my mum and my dad. And I feel it. So I don't believe it is legitimate to say, well, you should be contented with that, because it's not my fault that the world has evolved and I have to, let's say, go and travel and give a lecture. And of course, I love to be with this community or any community. It's a source of love for me. But I also will feel sad. So therefore, I would say, Mom, Dad, do it on this day, or I should do it on that day, etc. So that is something I can't control now. And fiqh cannot control it either. And it shouldn't attempt to control it. What it should try to do is to say, well, this is the predicament. So what is this system that we have? Let's come up with a principle of unity as a guiding principle of law, not as some social, ethical, spiritual principle, no. Not as a principle for dua, no. As a principle of law. Or dignity, as a principle of dignity, that somebody cannot be enslaved, for example. So there is a huge conflict here. And as you know, I think a year or 2 years ago, I did do 3 lectures on this. But there is conflict in the content of international law and the content of fiqh. Like women's rights, for example, like slavery, but I don't want to go into that. I've dealt with that, and you know these things. There is one final thing, which is to do with justice. Again, I alluded to this in the lectures in Muharram. This is just a speculation I have, which to some degree I think is coming true in certain countries. If the system of fiqh, or scholars or we as a community are not careful, fiqh can be used as an instrument for other people's abuse. And that is what is happening. So I'll give you an example, and I'll just remind this. So Article 2 of the Constitution of Bahrain explicitly states that the religion of the state is Islam. The Islamic Sharia is a principal source for legislation. The official language is Arabic. It's very wonderful. And then in Article 1b, it says the regime of the Kingdom of Bahrain is that of a hereditary constitutional monarchy, which has been handed down by the late Sheikh Isa ibn Salman al-Khalifa to his eldest son, Sheikh Hamad ibn Isa al-Khalifa the king. Thenceforward it will pass to his eldest son, one generation after another, etc., etc. So clearly, fiqh, or if you want it in the broader term, Sharia, is an instrument. One, to create a Muslim state, one, to coerce people, one, to give or hide behind the image of Islam, but then to use exactly the principle of Muawiyah and Yazid, which is the principle of the Umayyad dynasty, which is hereditary succession. If we are not careful, systems of fiqh can be used for other people's whims. And it is perhaps paradoxical, because at least within Shi'i fiqh, we have perhaps the most literature in comparison to other sects on Amr bil Ma'ruf and Nahy anil Munkar. It is there in chapters of fiqh. It is there in sermons and letters of Imam alayhi salam, in even other Imams' hadith. So, in a way, we have a good legacy, especially with Karbala, to develop norms for justice. But then we have to make it a value within fiqh. Or fiqh should respond to other states. Or fiqh should say, no, it is my responsibility, or scholarship, this is my responsibility to respond to the British economical crisis, where students are being charged high fees. And we, as I've mentioned here in this gathering, we have Letter 53 to Malik al-Ashtar, which explicitly talks about cash for honors, government expenses scandal, and a poor economy, and lays a few good guiding principles. And I'm not saying that everything is in there, but we should say fiqh as a system should respond to other people's crises and its own. And yet we are not doing it. And no scholar has said anything about it. Why? Because we have not caught on to the paradigm, which is that fiqh now has to catch up to the demands, not just of a globalized world, but the demands of what we can say now is a global mukallaf, a global responsible person to the law and to Allah subhanahu wa ta'ala, that, to be fair, can interpret the law as he or she wants. And then you have the normal question, which I think comes up, everybody says, am I applying the law of my mujtahid correctly? Normal question. I asked a question to this institution and organization, but I'm still confused. Why are you confused? Well, I have an answer, but then my context has changed within 1 hour or 1 day or 1 week. So therefore, people genuinely feel confused. And again, this is not just about the theory of fiqh, which I've only dealt with to a small degree, but it's to do with the practical operation and system of fiqh within the world. Salawat. So, as a conclusion, what kind of findings can we take from this, and can they collaborate? Well, there are very clear similarities. Fiqh, I think, has become an international law because we do ask that question. Is this law applicable in my country? And same thing with international law. There are clear differences in content, but there are theoretical similarities on how we are looking at the sources, at least a foundation and custom, etc. And there are still problems as well, because there is an issue of jurisdiction, which is the same problem for international law. So if I go to Australia or Pakistan or Africa, and I follow a jurist, then should the ruling of my jurist apply in that country, or should I then follow another jurist? Now, I'm not talking just about the reforms which has been said by Shahid Baqir al-Sadr and Murtada Mutahari and others, may Allah elevate the stations. But I'm talking about jurisdictional problems. It's one thing to say we'll create a committee of ulama and to have expertise. That's more internal. But I'm talking about jurisdictional conflict. One jurist in Britain says this, and then I'm in a totally different jurisdiction. And even the jurist in that jurisdiction, what access do I have? What happens if there's a problem, really? So this is a jurisdictional problem which also affects international law when nationals travel to different countries. And internet technology, which again I think is such a difficult thing to talk about because of what happens on Facebook, because of things like rape, because of the issue of mahram and na-mahram. There are reports, although they are not very prevalent, which was there recorded in the first Shia newspaper. I think a couple of years ago I read it. It's just called the Shia newspaper. I don't know whether it's still produced. And there was a big story in there about how a person went through the internet. I don't know whether it's Facebook or Yahoo, MSN at that time. And basically, she liked this other person, and in the end, basically, the other person ended up abusing her. Okay? Now, one of the things which you and I know is fiqh says that you respect the modesty of the opposite sex. You respect the hijab. Okay? Fine, this is wonderful. But in Facebook, as you know, for example, you can share any picture. Converse how you want to converse. It's no problem. You can write text. You can do what. In fact, the whole process of engagement and marriage is probably 50%, 70% is done on Facebook. So the concept of 1 meeting and 2 meetings and 3 meetings, I think 50 meetings has probably happened within that internet domain. For example, I mean, this is the reality. This is how people meet. So there, are people respecting mahram and na-mahram? For example, I'm posing this question. Are people respecting it? If some of them are fine, if some of them are not, okay, fine. What are the boundaries now? I mean, can I share 1 picture? 5 pictures? I don't know. I'm saying, do we have the answers to these things? Because this internet technology is moving at such a fast rate that the conventional ways that we can implement hijab are perhaps no longer possible. So again, then you look at the spirit of marriage, the spirit of beauty, the spirit of discovering your partner, all of these beautiful, which are maybe spiritual things as well, which are wonderful things. So how does fiqh as a system also tap into or nurture these very beautiful things left by our dear Prophet and the sunnah that he has left? So these are problems for fiqh and problems for international law. Same thing. Because international law is also struggling to keep up with international technology, especially in the case of terrorism. And you also saw in the Arab Spring how internet technology can be used very well to get your voice across through YouTube, etc. But again, controlling YouTube and these sorts of things are there. Salawat. So, inshallah, these are just my small findings. I really pray to Allah that I've tried to be as objective as possible, and I haven't drawn substantive conclusions, but this is just, inshallah, the beginnings of future research. So I open it up to any questions, inshallah.
Do any of the ladies have any questions? I have a question on values-based law and kind of deriving law on kind of foundational principles. So you were saying, for example, one principle might be unity, and so I presume that kind of that would subsume kind of differences between kind of legal scholars. My concern is that part of the system now is that there's a diversity of opinion, and that I guess that is a strength in that you're not kind of bound by one kind of interpretation of law. And when you start to have principles like unity, which kind of subsume these kind of variations between scholars, then you're potentially opening up yourself to kind of a monolithic interpretation of law, or kind of a consensual interpretation of law, which potentially is less diverse and less strong as a result. So I guess what would you say to something like that?
Jazakallah for the question. I actually agree with you, and I think that we only have to be very selective in promoting unity when our ibadah or our social cohesion is at stake. So Eid is one example, or Eid al-Fitr or Eid al-Hajj, where the ibadah is linked to the general worship of the community and the general thawab that you get. Or Friday prayer, for example, where again, you're looking at the unity of the community and guiding the community. The rest of the things, I agree, it shouldn't be monolithic. And you should have different interpretations and different opinions which poses. But when it comes to certain things where the community is divided, or fitna is there, or an-namima is there, sowing dissension and discord, and backbiting which results, this harms the nafs of all of us. So I think there we should be quite courageous, I think. So.
Any questions from the men?
Thank you very much. Opening up a whole lot of questions potentially as well. On the continuing on that, in terms of the values-based way of looking at fiqh, it seems from my brief reading of the things that there are so many examples of which are seen to be authoritative in every way, where a values-based look at something would be entirely contradictory to how fiqh has worked. So there are many areas where you look at many narrations which will show one idea and one message, but then you have exceptions, very, very clear exceptions to these things, which don't make any rational sense to us in any way. And any values-based derivation of law will automatically ignore such exceptions were it to do it itself. So how can we develop or think that a values-based derivation of law could really work when we know that Islam, or at least the fiqh understanding, does not do that in specific and many specific situations? In fact, almost every single law that we go into, every single bab of the books of fiqh will have examples of a very unusual situation, or very, very weird example of showing that something does not work. And going on from that, the whole idea that how qiyas or ra'i and all these ideas of analogy just don't work, the basis of them not working often is that we don't know what the rationale behind the law is, and therefore we will struggle to find out that values-based idea, because what our understanding of what that value is will be different. I mean, we have loads of examples of why qiyas doesn't work, and that same principle, would that not pose a problem when we're trying to understand how a values-based legal system would work?
Okay, Jazakallah. I think you're right that within the current system, the hermeneutic setup, yes, because that rationale is not explored, or epistemologically, we would argue that we can't be certain of that value. And our aql, therefore, is limited. And this is another discussion within epistemology. And I think that causes the issue which perhaps you are saying. Is that correct? That it's an epistemology, that we can't gain certitude on that value. And our aql cannot reach that value when it comes to derivation of law.
I'm potentially going even further and saying we might even be able to reach itminan or certainty that a values-based system is not what was intended, because there's so many examples where that was not the case. In every single situation you look at, we seem to have things which would engender some sort of certainty or close to certainty in all these different areas, that this situation happened and this is what the Prophet was or the Imam did in that situation. This is what happened, and this was an exceptional thing that happened, and this was a different, and it seems to be, you know, I don't know, you go to Tahara and you talk about a rat is 7 times you have to wash, and this, you have a value that comes out of cleaning or certain things that you think are the values, but you see that individual situations just vary in a way that doesn't seem to accord with the values-based driven.
Okay, I see. But I think that you can also interpret the opposite way as well, obviously. I mean, I think this is a sociological and historical question, not a legal question. It's how we view history. I think that is the fundamental problem here. If we view it in the way, for example, that you've said, then yes, you would say that that specific situation shows that this current system setup should be like that. But then you can look at it like Sahifatul Medina, the Charter of Medina, which is a rather value-driven charter. Or look at Letter 53. Or even when you look at specific hadith, where even the Imam has said, okay, this law applies, but forgive. It's better to forgive. So it's how we are pulling the law, I think. So I actually think that there are lots of examples where there are examples of values, but we have not pulled our legal system like that, nor have we viewed individuals' imams' decisions as part of a broader base of some kind of value-driven sunnah. Rather, we have viewed them as sort of some collection, as you said, of specifications.
I agree with all of that. So then going on to the next step in terms of ra'i and qiyas, and the fact that the imams were so harsh against the use of personal opinion in deriving law, how do we engage with that angle of things when we're trying to do almost something very similar right now?
Again, at least within the confines of my discussion, I still have to say, is it similar? One. Because there are lots of discussions on ra'i and qiyas and like specific discussions of how it was used, and some things that were allowed, something that weren't, and what was the specific issue at stake. And we know that people, even our later ulama, have redefined that no, the imams meant this, or this is what was the problem with qiyas, as you know. So first and foremost, first of all, I don't know whether itself that if you're talking about these concepts, whether they would be somehow haram or alien to what we are doing. And second is, anyway, we are not being subjective. We are still using the Quran and Sunnah as our source of values, like homosexuality, for example, or whatever we may derive. We're trying to create a value based on a foundation. Whereas if I ignored the Quran, maybe I would come up with a value that supported that notion. So I would not advocate that to that degree, but as free as it can be within using the Quran and Sunnah. Yeah.
Any questions from the ladies? Any further questions from the men? I think we'll end there. Thank you very much.
Okay, shukran. Surah Al-Fatiha, inshallah.